Hello, everyone. Thank you for joining us today. I am excited to welcome you to our webinar on record retention and integrated data systems. This webinar is hosted by Public Interest Privacy Center, a pending nonprofit organization incubated by AASA, the School Superintendents Association, in collaboration with the Data Integration Support Center at WestEd. The Public Interest Privacy Center equips stakeholders with the insights, training, and tools needed to cultivate effective, ethical, and equitable privacy safeguards for all children and students. The Data Integration Support Center at WestEd provides expert privacy, policy, and legal assistance for public agencies nationwide. So the agenda for today, we're going to take a look at what exactly is retention, retention and privacy best practices, then transition into some preliminary questions to ask when you're thinking about building out a retention policy, look at the legal questions, look at data retention in practice, and then we'll try to leave some time at the end for Q&A. And our speakers today, myself, Morgan Sexton, and I'm joined by Amelia Vance. I am Ethics and Privacy Counsel at PIPC and the Director of the Child and Student Privacy Center at AASA, the School Superintendents Association.
Hello, all. I am Amelia Vance. I am the founder and president of the Public Interest Privacy Center, Chief Counsel of the Student and Child Privacy Center at AASA, and also teach privacy law at William & Mary Law School. So very, very excited to talk to all of you today, but we have some caveats. So what is this webinar? We've just said many legal related things. And so why are we talking about this? Why are we focused on data retention? So earlier this year in our work with DISC, we got asked a question that basically can be summed up as what should be considered when you are building a record retention policy. And shockingly, as we were searching for what are the many resources about this, there really wasn't one. In fact, if you look up resources for data retention specifically, you only have a couple, and they tend to look at very specific aspects of data retention. You have a lot of mentions of data retention in the context of a broader data governance system, but you don't really have a specific, here's what you should be looking at. Here are the questions you should be asking and what you should be examining as you look at record retention policies. So the focus today is the questions that we came up with in answering this question, because of course, as lawyers, the response to any question is, it depends. And hopefully that will provide some guidance for those of you who are interested in digging more into data retention. And we'll talk a little bit more about next steps. But as I said, some caveats. We are lawyers. We are not practitioners here. We have learned from a lot of practitioners, but we are likely to get some things wrong or misstate them. Please do let us know if we do. This is meant to be a resource. This is meant to be something that can be used in the future, can be developed into a broader resource. So tell us what we're not thinking of too. Let us know what you think about the framework that we're going to walk through in some of the examples. So with that, go ahead and dive into the very important question of what is retention?
I was muted. I'm so sorry. So the overall framing concept for today, what is retention? So a lot of times when we think about retention, we think about is it how long we can hold data, or is it the minimum amount of time we have to keep it? But really, if you think about it in the context of the overall data lifecycle, we're talking about everything after you capture, after you collect the data. So it's not only how long can you keep it, it's how are you keeping it? And when it's no longer useful or no longer needed, what are you going to do with it? How will you get rid of it? So it's a lot broader than just the length of time. And that's generally how we've been thinking about retention. So I really like this quote from IAPP describing retention because it also hits at it a little bit broader than what we hear a lot of times. So within the information life cycle, the concept that organizations should retain personal information only as long as necessary to fulfill the stated purpose. I like this because it's not a hard line of keep it this long and then get rid of it, or yeah. So it's flexible, it's malleable, and it's a lot more than just the timeline that you must retain information.
Absolutely. And building off of that, retention and privacy best practices, retention really is embedded in what can really be described as the foundational principles of every privacy law, privacy structure in the world. So many of you know, but I've recently been told that some people don't know about the fair information principles, fair information practice principles, called by various names. It is the source of much debate. And specifically, what the principles are tend to center around these terms, though they may vary depending on the agency, the country, or other things. But the key principles here are really transparency. People should know what data you have about them and what you'll use it for. This idea of data minimization, having a specific, really related to this focus collection or purpose specification. You collect the data you need, you use the data you need, you retain the data you need. You have what question are you answering in focus collection and what data do you need for that? Purpose specification, where you have what is your purpose and not using that data for another purpose unless there's consent or some related allowance. Respect for context. So again, why was the data collected in the first place? How is it being used? Something that's particularly important when you're talking about sharing data between different systems. Individual participation. How do you give people access? How do you give them the ability to correct information, to request deletion of the information, making sure the information is secure? Data quality. If you have the information, it does need to be accurate. And then accountability. How do you make sure that these other principles are upheld? So when we look at the FIPS and retention, and apologies for my slight historical soapbox here, there, as I said, are many versions of the fair information practice principles. And one of the first ones was out of the UK. And it was very specific to essentially integrated data systems or general agency data systems. So it was really built foundationally around how should we treat data in an information system about our citizens. And one of the principles that was put together by this committee, and at the same time you had across the Atlantic, you had the US coming up with their own very similar versions. But specifically, the Younger Committee said in the design of information systems, periods should be specified beyond which the information should not be retained. So having this recognition that data minimization is important, that we just shouldn't perpetually keep data forever. And so when we're talking about how retention interacts with all of these, with all of the different FIPS, much like the picture of the data lifecycle that Morgan shared, you have considerations related to retention throughout the FIPS. So with transparency and openness, the idea that you need to be able to tell people the data you have. You need to be able to know the data you have, know which data you've gotten rid of. Basically, having a handle on transparency involves having a handle on the retention of the data you have. Data minimization, as I said, really focused on what is the retention limit, but also have you specified the purpose for which personal data that are collected will be used and limiting subsequent uses. with focus collection, with others, thinking really carefully about how your retention schedule, how your retention policies are ethical decisions, are foundational decisions that show whether you are using data only for a particular purpose, whether you are respecting the context in which that information was collected in the first place. Similarly, individual participation, how are you giving people access? Lots of implications for retention. How are you protecting the information? How are you making sure that it is, in fact, reliable, accurate? Thinking about, again, how do you ensure that these principles are upheld? And then also a couple of FIPS that are not talked about as much. So going back to Great Britain for the moment, um, there's a couple elements, again, because this 1972 committee was a little more focused on agency data keeping and information systems, where it says that a record keeping organization shall bear an affirmative responsibility for establishing reasonable and proper information management policies and practices, which assure that its collection, maintenance, use, and dissemination of information about an individual is necessary and lawful, and the information itself is current and accurate. That is from one of the other US commissions in the 70s, the Privacy Protection Study Commission, noting that you need to have sort of this data maintenance, data lifecycle caretaking process. And so retention is something that will be discussed throughout your data governance work, but broadly, it is very important to make sure that retention isn't, as noted earlier, just something that's sort of how long do we keep this, but instead embedded into questions across the data lifecycle. I have also here this protections against automated judgments. One of the big questions that I've been getting is what can we do with data related to training algorithms, automated systems in general, all of these different things. And this is where we actually have some lessons from the 1970s as well. So first of all, you have, the younger committee in the UK saying that in computerized systems handling information for statistical purposes, adequate provision should be made in their design and programs for separating identities from the rest of the data. So this idea that retention isn't just about deleting information, it's also about protecting it in different ways, in different layers. But then also that care should be taken in coding value judgments. When we are automating anything, we are knowingly or unknowingly coding value judgments into how decisions will be made by the data that we are choosing to include or exclude, how we are deciding how to interpret or not interpret the data in a data dashboard. And so, again, all of this goes back to this idea of retention. How will the data be retained or not retained? So, with that, before we can dive into sort of that data lifecycle idea and some of the concrete questions, we need to talk about some preliminary questions. So, this is not a standalone webinar by any means. Anyone who is introducing themselves to data systems should go and watch something earlier, because this is very much so for those who are a little more in the weeds, have created the data system or building a data system. Because if there isn't a value proposition, then what's the point? Why do you have data if there is no purpose behind it? If there is no value to the community? If there is no specific question you're answering, it really only opens up security vulnerabilities. It opens up, opportunities for harm. Unless we can justify why we have the data, why we are collecting it, using it, sharing it. And so when we're considering retention, making sure that we're not considering it in a vacuum, but looking at resources such as actionable intelligence for social policy, steps to effective data sharing, where you have to have this strong vision, mission, and purpose, have a core group of stakeholders think through the data that will be needed for specific questions. What is your common goal? What questions are we answering? And what data do we need to do that? So, a preliminary step there before we now dive into sort of data retention is also the question of data inventories. So, I really enjoyed watching a webinar recently with the Chief Data Officer for the Illinois Department of Innovation and Technology, where she noted that when I think about the easiest way to get everybody on the same page of what protections apply to a system, what protections apply to a data point, what protections apply to a data set, data inventories enable stakeholders to come to the table from the various agencies, from research organizations, whatever it is, knowing which laws apply before the data sharing conversation even starts. They know what data they have, and then they can say, here are the laws that apply to this, here is how much data and what types of data that they can then share. So, starting with your data inventory, Morgan.
So we developed a couple questions to help you figure out what data you have to aid the analysis later on, like Amelia was just talking about. And essentially they boil down to what categories of data are collected. So you need to know where they are, who owns them, and what you have. It's a very foundational beginning. And then look at those categories and ask, are any of them particularly sensitive? And this will become especially important later on when you're deciding what levels of protections and what will be necessary for each data element in the system. And then another thing to look at is, what is the source of your data? So where is this data coming from? Is it state agencies, third parties, public records, individuals? Another place that we didn't think of to include in this list. And once you go through and really do a thorough data inventory to see what you have, you ideally will be able to end up with something like this. So this is from North Carolina's longitudinal data system. You can see it has the system, sector, source table name, field name, and a description of the data element. So really going through getting each element and seeing what it is and where it is, essentially. And also this example from California's Cradle to Career data system is really great because it does the same thing. It breaks out those data elements and it shows the providers, so where they are getting this data from. And it also includes a timeline for data inclusion, which can be helpful when you're evaluating the system. So that wraps up the preliminary questions, and we're going to transition to some legal questions. We'll start by saying you have to consider federal law, and there are a bunch of different federal laws that could apply to your IDS. It all boils down to where your data is coming from, what you include. Every integrated data system is going to be different, but that's why the inventory is so important. So privacy laws in the United States are sectoral. So there are a bunch of different privacy laws that apply depending on who holds the data. So while some medical information may be covered by HIPAA, some may be covered by FERPA. And it's going to be really important when you go into the system to identify what type of data it is, who owns it, who it's from, like all of that, so that you can make sure that you're applying all the federal laws to all the different data elements that are in play. And we have a recommended resource linked in the slides, and we will be sending these slides out afterwards. So don't worry about jotting down the names right now. And yes, so after federal laws, you also have to look at state laws. And this is one that is often overlooked. So your state could have specific laws on statewide data systems, integrated data systems, state or local agency data collection, use, retention, sharing. And again, every state is different. So where you are is going to be very important for your retention and how you are allowed to maintain, retain, and when you must delete data at the end. So you can look. Oh, sorry, Amelia, I'm going to turn it over to you real quick.
Yeah, I just want to flag this looks pretty simple, and it is pretty simple, but want to bring back the fact that, as we were looking at the different resources that were out there really wasn't a straightforward list saying where to look. Well, certainly, relatives over Thanksgiving dinner think that any lawyer knows everything about the law, including how to get them out of that speeding ticket. In fact, everyone comes to the table knowing their sector, knowing only what their area of focus is. And so, as you may be looking at crafting a retention policy, helping others craft a retention policy, really digging into stuff that seems simple, stuff that, of course, lots of state laws may apply here. Oftentimes, you may not get people who realize that, for example, as long as necessary for the purpose is, something that relates to data retention. And so really want to emphasize how much the basics do need to be covered, especially as you may be bringing on new employees, as you are developing these policies yourselves, because the checklist means that ideally you are not leaving anything out.
Yes, thank you for adding that, Amelia. That's really important. So does your state have any laws on basically anything having to do with your IDs, since every state is so different? Do the laws say anything about data retention? Does the laws limit anything about the specific types of data that you have, or the source of the data, or what you can do with data that you receive from certain individuals? And then what are the relevant state laws or regulations about when information is sufficiently de-identified? And does that apply to all data or just a specific type? So as you've seen, this can vary a lot across states and sectors. To demonstrate this, we pulled a few different approaches we've seen, particularly in education, which is where we focus. So we spend a lot of time looking at education laws. But I just want to show you how seriously states can vary within even the same sector. So this is from Hawaii, and it's a bill that did not pass. It was carried over to the next regular session, but it's stating that the state currently has no uniform requirement for retention for records or for student records. And the bill was to make it 100 years, but it did not pass. So I think it's still no uniform requirement, but double check me on that. These are just ones that we've seen. And so we see Alaska, it's until the student graduates or withdraws plus 60 years. And then there's Delaware, which is through the end of the year when they graduate or withdraw, then 75 years. And then there's Missouri, 75 years and destroy, or 5 years after graduation then destroy, just depending on what exactly the record is. There's Indiana, which has things marked permanent, so forever. And then there's Virginia, which is compliance with applicable laws, which referring back to those federal laws we talked about earlier. So there is a very wide variety across education, record retention in the state. And it's not just education. So we went through and pulled a couple examples. This is how a couple different states treat some workforce data retention. So we have Wyoming retain I-9s for 3 years after separation and destroy. Florida, retain I-9s 3-year anniversary from the date of hire or 1 year after date of termination, whichever is later. And then we have North Dakota, current fiscal year plus 2 years for employment and age verification certificate. So again, very different, and you're really going to have to dig into your state's laws specifically.
So, one of the questions that we had on that initial slide that I want to emphasize is what are the relevant state laws or regulations about what constitutes sufficiently de identified information? And also, what federal laws or regulations require for all the data or particular type of data? Oftentimes, particularly when we're talking about agencies working with administrative data, there's this belief that you can just take a name away and the record is de identified. But of course, under Family Educational Rights and Privacy Act, there's actually a very high standard for what de identified can look like. You have a number of states that may require, particularly under recent laws, that data be at an aggregate level when shared. So, not even de identified, but more towards the anonymous end of the spectrum here in this great infographic from Future Privacy Forum. So, really being careful as you talk about sort of data de identification and ask about it, because everyone's baseline understanding of what de identification is, requires, is going to vary extremely wildly. So, once you get past the laws, the more obvious step, there are obviously contractual provisions, which would seem very obvious, but I have surprisingly found that once the contract is actually signed, people don't always go back to look at what the contractual provisions are related to retention. So, some of the questions we have related to this are what is the relevant MOU or data sharing agreement, data licensing agreement say about how long the data can be retained? Again, does the same standard apply to all data or only specific types of data, student, juvenile justice data, health data, et cetera? Who owns the data? Who maintains ownership? Is any ownership transferred? Because then maybe the retention standard changes based on the agency or the entity that is then owning some of the data. Again, is there a standard of what constitutes sufficient de identification or a requirement for disclosures around de identification and aggregation? And then, very important here, sharing data with third parties. Are you required to put the same restrictions on those third parties that you yourself have? Because that applies to data retention as well. And in thinking about this, I really love this graphic from the GovLab and IDB, which talks about the contractual wheel of data collaboration. So you have the when, where, why, what, who, and how that helps you figure out what should be in these contracts. And data retention is, as you can see, a step here in terms of when will data actions take place and at what point does the agreement start and end? What do you say about data? Because oftentimes, again, it's not listed as data retention. There's not often a separate data retention mention. So, as you're looking at data retention specifically, as you're looking to say, okay, here's what our agency requires, you're giving instructions to someone to research on this point, knowing the forms that retention may show up as in some of these agreements is very important and very useful because otherwise legal information may be missed. So, this is a wonderful resource. The Contracts for Data Collaboration has a number of contractual provisions. So, you see in this State of Louisiana Department of Education data sharing agreement, specifying when the student information is no longer needed or when the agreement is terminated, data should be destroyed. You have other agreements here, video and traffic flow data sharing partnership agreement that says that, you can have this extension of the contract, but when you are sharing information, you have this right of cancellation, at which point you have to get rid of the information. You have this MOU between Johns Hopkins University, Morgan State University, and Baltimore City Public School System, talking about how the data needs to be delivered back to the city schools, all of the data obtained in whatever medium that contains the data provided as a result of this MOU. So you might really see a variety of ways that data retention comes up in contractual measures. And then standards. I included this awkwardly between legal requirements and what you need in practice. As many of you know, if you have certain federal grants, certain other things, then there are specific technical standards that you may need to adhere to, either by law, by the terms of that grant included in one of those contracts. And so specifically digging into the fact that each of those different standards have their own data retention requirements. Then when we look at data retention in practice and the questions that need to be asked to develop that policy again, very important to note that while you may be building a retention policy for the first time, maybe for a new state data system, there's probably several that already exist. And there may already be one that exists that just has been set aside. So looking at the data governance policy. But if there isn't a policy, there are some great resources that we pulled from IES and the SLDS support team, talking about what needs to be included in certain data policies and processes, and thinking about how you pull all of this together. It's also necessary to consider data classification. So not just sensitive and non-sensitive, but the AirDiff Advanced Education Research and Development Fund specifically has for their data system a slightly different classification where they look at non-public information on one hand, de-identified, non-sensitive, proprietary. So looking a little more broadly to make it easier to differentiate between those with legal requirements, those that may just be more sensitive. And this is something that AirDiff has been evolving as more data has been added to the system. And what this might end up as is this really wonderful table from Daisy's data retention and data destruction guide. So this is the Center for IDEA Early Childhood Data Systems data retention and destruction policy template that I cannot recommend enough. So looking again, something that looks very similar to that data inventory where you have your type of data, who is the responsible entity? What is the schedule or procedures for archiving or storage? What is the retention duration before destruction, if it is in fact destroyed, or is it archived instead? Is it de-identified instead? And then what is the type of destruction? I've always gotten a number of questions about, do I just take the computer out back with a baseball bat? And as many of you know, it is incredibly complicated, and there are specific requirements in many cases in contractual agreements or in legal frameworks about how to destroy data or what constitutes sufficient deletion of information. So having that laid out in a chart like this can be invaluable. So the other questions to consider here that we wanted to mention as part of looking holistically at data retention include under sort of the label of underlying purpose. So how did the original purpose of the IDS guide which data is maintained in the IDS? Why do you have the data there in the first place? Are there mandates or requirements that necessitated the collection of the information, and are they still relevant? Are there specific goals or insights that you're hoping to meet or obtain that are guiding which information you collect in the first place? And is that data really necessary to achieve that purpose? And by that word necessary, I don't mean, it's possible that by combining five other data elements, you could, get to that. And so you shouldn't use the sensitive data point. Use the data that's necessary to answer the question, but make sure that your specific question is being answered by that data. Because if you're just collecting it and throwing spaghetti at the wall, then you're retaining data that could be harmful either to the data subjects themselves, to your institution, be revealed in a data breach, etc. Could you arrive at that goal or insight without retaining the information by retaining other categories of less sensitive data, by only retaining this data in de-identified or aggregated form? Again, data retention is not a black or white. It is very much so a spectrum of possibilities of how you are making the data less available or less identifiable. And is that goal or insight worth the potential of harm that may result if there was a data breach, if an employee accessed the data inappropriately? With data utility, so when will the data no longer be relevant to or useful for the purpose for which it was originally obtained? When does it become stale? I think my favorite phrase that I read in doing this work was, do you have a data graveyard? Is there is there data decaying out there that really doesn't need to be there? Because of course it is so much cheaper to collect data and not look at it than it is to spend the time going through it, which is where, again, you have that preliminary importance of having that data inventory and awareness. What are the limits that apply to the secondary uses of the data? If limits exist, does that mean certain data points are no longer useful to retain? Do the limits apply to all types of data, only certain types, only from certain sources? How long is it practical to keep longitudinal data? Oftentimes, there's sort of this vague standard of a decade, somebody pulling a number out of a hat. But thinking very practically, when you are doing longitudinal studies, what do you want to learn between different generations, between what somebody was doing at one point in their life and another? How is that going to be useful? And as you're building your retention policies where law doesn't apply, where contractual measures don't apply, will you actually use this longitudinal data? What is its value? What is your system's capacity for storing the data? Is it the most useful for your purpose, or would other data actually serve you better in the long term? How are you ensuring that data retained in your system remains accurate over time? Something that's incredibly difficult. And then, unsurprisingly, safeguards. What are you implementing to protect all the data that you do retain? Because you do have an obligation to protect the data you have. So, are you de identifying or aggregating the data? Have you ensured that it cannot be re identified? Have you implemented appropriate role based access controls for different categories? And are there additional safeguards in place to protect particularly sensitive data? I've always been really fascinated by New Jersey's regulations related to student records, which actually require that health information be kept separate from the rest of the student record. Um, is the data subject to higher protections under law or contractual provisions? And how do you apply those higher safeguards in those cases? And then, of course, that final step in that spectrum of retention, deletion. How will it be deleted? When it comes time to delete it, how will you ensure that, very importantly, only the intended data is deleted, since you don't want to accidentally sweep in other data that may be valuable, that deleted data is irreversibly destroyed, that third parties honor their deletion responsibilities, which I'll talk about in a moment. And after deletion, what procedures will be used to verify the data is no longer available in the system? And then, sort of, this final piece of the puzzle. So we were talking quite a bit about what you should be looking at and asking internally. And then you have, well, what about those third parties? What about the researchers or others that have data and are now going to have their own retention responsibilities and considerations? This is a list from a data management plan created by AirDiff. All of these different questions relating to data access and use have an impact on what retention standards, retention limits, retention security, et cetera, that should be implemented. So questions around when will data be anonymized? When will data be identified? Describing how you process data, describing how you will provide access to research staff. All of these different things that ensure that data is protected throughout and can better help you control third-party uses or sharing of data that should not be permitted, that is not allowed under your own state record retention statutes or others. And part of that can also involve this great template for a data destruction assurance form. So very specifically including that you have this requirement for destruction, that you include in your contract, here is exactly what has to be done. But of course, this can apply more broadly to other instructions related to retention, to what can be shared, to what should be considered. So we promised you at the end of this some next steps. So PIPC is working with DISC on a publication that builds on these questions. And we want more examples. Where are our questions lacking? Where can we have more guidance? Where can we have more specificity? Again, we are not the practitioners here, and we want to hear from all of you and want to provide something that supports your work. If you, like our colleagues who we mentioned at the beginning of the webinar, ask the question, how do I build a record retention policy? That it's something that enables them to do that. So with that, does anyone have any questions? While we're waiting, I'll just mention that this is also really important when you're considering new data that may be collected due to technological innovations. So looking at state record retention statutes is particularly important because you may have antiquated terminology that fits awkwardly over current technology. So a particular state required that voice recordings be kept for a certain amount of time. And so when teachers began to bring Alexas to school, you started to have some questions about whether you could delete the accidental turning on of Alexa kindergartner voices, or whether that would violate the state statute. So keeping an eye on what is outdated or what may not be outdated is very important in both knowing what your obligations are, but also considering whether they may need to be revised. So we have a question here. How do you prepare the parties that will receive and store the data that will receive it, that they will receive? I'm not sure if I'm clear on that, but basically, how do you anticipate not having someone show up with a box of files and the school secretary just puts it in a closet? Good point. I've definitely heard some examples of data being shared in ways that are not secure, whether it's emailing an Excel spreadsheet to provide information from the student information system, or other things like that. A lot of that is something that can be built into that MOU or the data sharing agreement. So specifically saying, here's how you should provide data to us. Here is what is required. Here are the safeguards. Here is how long you should keep it. So building all of those elements in upfront can be really helpful in avoiding someone showing up with a box of files. Any other questions? Morgan, do you have anything to add on that one?
No, I think that answer was great.
Seeing no other questions. Oh, here we go. This is an interesting one. How did we end up here discussing data? Love to hear the personal stories. Keep it short and sweet. Started working on tracking legislation related to state curriculum and assessment data that was showing up in state legislatures. And then privacy became a huge issue. And so I was pulled from pulling just the legislation on data sharing and required, assessment data, et cetera, to also look at restrictions on data sharing. So some broad pulling into privacy just by the controversies of the moment about a decade ago. So happenstance, but definitely an area I love. Morgan?
My story is much briefer. Amelia was one of my professors in law school. She was teaching a privacy law course, and I loved it. And after law school, after studying for the bar, I started working with Amelia and got to join her on this exciting work.
Well, that is a high note. So with that, we will go ahead and give you the remainder of the hour. Thank you so much for joining us. Please do share any other feedback that you may have as we develop this resource. We're really looking to create something that is useful to all of you. With that, have a wonderful rest of your day, and thank you so much for joining us.